Reckless driving in the state of Alabama. What is it? What does it take to prove it? And what would the sentence likely be if convicted of reckless driving in the state of Alabama? The reckless driving statute in Alabama is 32-5A-190. Essentially, in order to prove reckless driving pursuant to the statute, the prosecutor would need to show that someone obviously was driving a vehicle, and the specific wording of the statute is very important. Section A says, any person who drives any vehicle carelessly and heedlessly in willful or wanton disregard for the rights or safety of persons or property, or without due caution and circumspection, and, that's a big and here, at a speed or in a manner so as to endanger or be likely to endanger any person or property, shall be guilty of reckless driving. It's very important to understand the meaning of those words and to break the statute down in the event you're charged and make sure that the words in the statute are understood by the court throughout the process, and that the ands and the ors within the statute are all met. Anytime we have a reckless driving trial set, we go through the statute and the conduct that is alleged and break down the definition of the word carelessly. We attach the and with it, obviously, look at heedlessly, and then we look at willful, wanton, and we look at the rights, whether it's a person or the safety of the person, and also any issues related to property. It's very important when someone is charged with reckless driving that they have a thorough evaluation of every aspect of the statute and of the conduct. It's very, very important, because what some believe to be reckless may in fact not be reckless driving under the statute. Many times, of course, it is reckless, but it is the case that sometimes it's not. And it's very, very important when a case needs to be litigated that the statute is compared to the facts, and that the definitions of all of the words within the statute are well understood and are applied to the facts of the certain case that is being defended or is being tried. Section B of the statute covers the punishment and essentially says that every person who is convicted of reckless driving shall be punished. If it's a first conviction, they're going to be punished for imprisonment for a period not less than 5 days nor more than 90 days. Of course, all of that can be suspended, and a fine of not less than $25 nor more than $500, or by both. If it's a second or subsequent conviction, then they should be punished by essentially jail time, which would include not less than 10 days nor more than 6 months, and all of that time can be suspended as well, and the person could be placed on probation, and the fine there is not less than $50 nor more than $500, or by both. Now, there's a lot of people out there that think that on a reckless driving conviction that their license is not going to be suspended. The item that is very, very important for people to understand and to realize is that the court, now this takes the discretion out of the hands of the Department of Public Safety. The court has the discretion to prohibit the person convicted from driving a vehicle on the public highways of this state for a period not exceeding 6 months, and the license of that person shall be suspended for such a period by the Director of the Department of Public Safety under Section 32-5A-195. Very, very, very important for this to be recognized and to be understood. There are courts in the state of Alabama that attempt to suspend someone's driver's license anytime they are charged with the charge of reckless driving. The court may have a policy to do this, and it may be standard practice, but it is not required, and that aspect of the case should be litigated and should be prevented in most circumstances, depending on the facts of the case and whether there are severe issues related to the facts, or if something occurred that could possibly warrant an enhancement for a driver's license suspension. This section of the code under Section C also goes over that neither reckless driving nor any other moving violation under this chapter is a lesser included offense under a charge of driving while under the influence of alcohol or drugs. And that is gone over as well in the DUI statute, which is 32-5A-191. My name's Joseph Kreps. I'm an Alabama reckless driving defense attorney. If you have been charged with reckless driving or any other traffic offense in the state of Alabama, we want to talk to you about your case. Do not simply walk into court and plead guilty thinking that you have no other options. You have plenty of options in attempting to resolve your reckless driving charge in Alabama, and you need a qualified attorney who has handled thousands of traffic tickets in the state of Alabama, and we can help you. All you have to do to begin the conversation is call our office. You can reach us at 866-348-2889. You can also visit our website, alabamarecklessdrivingattorney.com, or trafficticketattorneyinalabama.com. Thank you very much.